So I have a presentation today. I'm an attorney in Painted Post, New York, and what I'm going to be covering are three main things, and I'm going to try and keep us on track as well as I can. So I'm going to talk a little bit about business entities and what kind of liability or protections that they can provide. I'm going to talk a little bit about having some kind of contract or agreement for people who are coming on to your property if you're hosting events or if you're doing something on a farm or something of that nature. And then I'm also going to briefly touch on the New York State Agricultural Tourism Safety Act that I believe that was passed in 2017 that became effective. So the slides that I'm going to be presenting, I did provide. So if you guys want copies of the slide, just let the organizers know. I'm happy to give you the slides if you would like. But I am just touching on things very tip of the iceberg. I have about a half hour. I'm going to try and leave time for questions at the end because I do have to hop off for another appointment. But I will take some questions and you can also follow up with others. But this does not replace you sitting down talking to someone specifically if you're planning to do some of these events, or if you do have some kind of legal issue. So with the legal entities, I am just going to touch on each of the five main types of legal entities. There are some categories like partnerships can have limited liability partnerships, but I'm going to just be talking about at a very high level. So starting with a sole proprietorship. So the sole proprietorship is when a person simply decides they're going to start a business. They are unincorporated, meaning they're not filing anything with the state. It is owned just by a single person. And I mean, it's very simple to set up typically because you don't have to file anything. There are not formalities that are required. Your tax return is just picked up on your own personal tax return. So, but with a sole proprietorship, there is unlimited liability. So if something goes wrong, it's not just the assets that you consider business assets at risk. All of your personal assets are at risk. If you don't have the proper insurance or if you get sued in a lawsuit and it's not covered by insurance. So next is a partnership. So a partnership is a legal arrangement that, two or more people generally come together and they're going to run a business and they're going to share the responsibilities. Partnerships can also be very informal. In New York State, you do not have to have something in writing to form a partnership. I would suggest you do have it. Taxation of partnerships can be very complex. They do a separate tax return, but you and the partner or partners can decide how you want things done. How are things going to be run? Maybe one person is doing more work, so they get more of the income. But generally with the partnership, there is unlimited liability there as well. So if something goes wrong, if you are getting sued, you are not limited to just whoever is suing you. They can get at your personal assets again, not just the business assets. The next three, so a C corporation. So the letter C actually comes from the IRS. It's the part of the IRS code, but it's a structure for a corporation where the owners, the shareholders, are going to be taxed separately from the entity. Now, with a corporation, you do have to file with the state. So you're going to have to file with New York State or whatever state you're doing business in. And one of the things here is it has its own separate tax return. But because of that, a corporation, when it earns a profit, after you take all the expenses out, the corporation itself will be taxed. And if they then make distributions to the shareholders, that's the dividends, it is taxed again at the shareholder level. So, but there is limited liability. There are some exceptions to that, like when it comes to like payroll and payroll taxes that you can be personally responsible. But for other things, if you're being sued on something else, typically there's going to be separate liability for the corporation. And if you have structured it right and if you follow the rules, it will limit the liability to the corporate assets. And the other side, it goes as well. If you are a shareholder of a corporation, but you are being sued, the business assets are also protected from your personal things. So it's actually a wall that goes both ways when it's done correctly. Next is an S corporation, and this is what I tend to see a lot of, at least around here. So this is still a corporation, but it is an election that you make with the IRS, and you also do it with New York State, but it becomes a pass-through entity for taxes. So we don't have the double taxation because the income, the deductions, all of that is going to flow through to the owner, and they will pay the tax on it. So that way, if there are distributions from it, it is not taxed twice like there is in a C Corp. But you have to apply, you have to get approval, and there are very strict regulations from a liability standpoint. Again, if you do it right, though, you get the same liability. It will limit the liability. You will not be personally liable, except for a couple exceptions like the payroll tax. And then the last entity, and again, this does require a filing with the state, limited liability companies. So it's a business structure where the law will protect the owners. They're called members from personal responsibility for debts or liabilities, other than the few caveats of like payroll taxes and payroll, but everything else, the business, you're going to have the protection from the limited liability company. The limited liability is the newest creature of all of these, and they are governed by state law, so it will vary state by state. But the law will put in, what the protections are and what the responsibilities are. As compared to corporations, there is a little bit more work that you have to do right up front to set it up, and it costs a little bit more because of that work. But there's less ongoing formalities that you may need to do. Like, it does not require minutes be filed every year like a corporation. You are actually, the law states you are required to do corporate minutes at least on an annual basis. So of the five, the corporations, whether it's a C Corp, an S Corp, a limited liability company, they're going to be the ones that provide you with the most liability protection. But it's still important to make sure you do it right, because if you set up a corporation, if you don't do the minutes, if you don't treat it like a corporation and keep it separate from your personal, then you are risking that they will look through the corporation. But if you do it right, you can limit your liability there. All right. I'm going to talk a little bit. I'm calling these event contracts. This may not just be for events. Just depending on what you're doing on the farm, what I did, I came up with kind of a list. If you are having people come onto your property for something other than retail, in retail, Jenny's going to cover all the insurance aspects of that. But if you're doing events whether someone is coming on to do an activity that you're demonstrating, or they're participating in an activity, or even if it's as simple as, you picket flowers or fruits or things like that, I would consider that an event, and I would consider having an agreement. So these are the 12 things. I'm going to go through each one really quickly. So the first thing that I think you should have in that kind of agreement is a description of what are they doing, what are they coming onto the property for, what activities are they undertaking, to make sure that it's clear. And usually you're going to have a general clause too that says, any similar related activities, but put your description exactly, what are they undertaking right in the agreement. Next, I like to see a statement about the awareness of risk. So this is going to be in the statement that they are aware of the risks. And this is where I would list, things that may come to mind of, that may happen. So if you have a farm, if they're visiting animals, if it's like a petting farm or something like that, that these are still animals, and animals can be unpredictable. I would be putting, so there's going to be a statement that they are aware of the risk, but the risk that you can think of, this is where I would also list those types of things. So one, we were talking before we got started, even you pick flower farms, that should they put a statement about bees? Well, part of me is saying, if it comes to your mind that, hey, because of the flowers, it attracts more bees and people are going to be on and cutting their own flowers, yes, I would put that risk in that agreement and then put it in this place. So you want a statement of the client or the participants' awareness of what the risks are. Next, I want an assumption of the risk. So after they've been apprised of what the risks are, after they say they're willing to do that, that they sign a statement saying they are assuming those risks, that they are accepting the personal responsibility for their involvement, of those risks. because as you're going to see later on, we're going to be talking about the law. With the new agricultural safety law, if you're providing this, you are going to be protected from the liability. So we want a statement that they are going to assume the risks after they've been informed what they are. Next, I like to have something in there that they have an agreement that they're going to follow instructions. So this depends on what you are doing, but there may be areas where are they allowed to go or not go, but they're going to follow the instructions. They're going to follow directions, whether the instructions are given in paper, whether you're giving them, verbal instructions. I want them to have an agreement that they're stating they will agree to those instructions. A statement of the release and indemnification. This is the part that everyone really wants in there. So this is a statement that, if something goes wrong, and, because it's one of those inherent risks, that they release you from the liability, and the indemnification part that they acknowledge they're going to be responsible for damages or expenses. So if they get stung by a bee and they're allergic and they have to go to a hospital, they've accepted that risk. They're going to pay for, the hospital costs, their copay, things like that, that it's not on you. So, so we want some type of clause for the release and indemnification. I like to have in there a statement of fees for damages. Again, this may be what it's for, but if they or their family or whoever they bring on, if they cause damage, so if you're doing the flower farm we talked about earlier, and they don't go on the path and they trample the flowers and they're causing damage, that they agree that they're going to pay for any of those reasonable damages. So next, the applicable law. I did not ask up front, but most of everything that I'm going through is based on New York state law. Although for these agreements, these would be similar in other states as well. But I'm going to put right in the agreement, because you may have people, especially, so I'm in Corning, New York. We are very close to the PA border. If you're running a farm or something in New York state, you're probably going to be attracting people from other states, whether it's visitors or Pennsylvania. But I want a statement of, if there's going to be a dispute, where is that going to be adjudicated? It's going to be adjudicated here where your business is. So you have control, what the law is going to be. When they sign it, I want a statement in there that they're signing of their own free will, that they're going to sign the agreement, they're not being pressured. And you can make it that, if they don't sign the agreement, they don't get to participate. But I want a statement in there that they are signing of their own free will, that they're not being pressured by someone to do it. We put in what we call an anti-lapse statute. So an anti-lapse statute says, if one of the provisions, if one of the paragraphs that I've covered is for some reason not enforceable, it doesn't mean the entire agreement is not enforceable. It means just that one part of the agreement is not considered enforceable. So that's what an anti-lapse clause is in a contract. Now here, this may depend, this could be optional, but if you are recording, so one, you may be taking pictures or video and using that as a part of marketing materials. And if you are, you definitely want the second part of this, where I say that you want it to state that they realize they're not entitled to any compensation. But even if you are not doing it for marketing purposes, maybe you're doing it for safety purposes, you have video cameras up, you want something in there that they understand that there are pictures and videos being taken with respect to that, even if you're not using it in your marketing materials. So one, I want to have a statement, clearly indicating that they understood everything that's contained in the agreement, and that if they don't understand something, that they will ask so they feel comfortable that they truly understand it. I don't want someone to claim that they didn't understand, and as I've explained this, it doesn't have to be a lot of legalese with this. There's probably going to be a little bit in the contract, but make it as plain English as you're able to. But I want a statement there that they, and I didn't really put it in the slide, but you probably want something saying that they've read it and understood it. So that they've read the entire agreement, they understand everything contained in the agreement, so they can't claim that they did not know what it meant. And then the last thing I usually put at the end of these types of contracts, I'm going to put a statement that we as the owner are relying on, when you sign this, that you have read and that you are agreeing to everything above. That if you hadn't agreed to it, we would not allow you to participate. So, I want it clearly stated that you as the owner are relying on the statement they're making that is allowing them to participate. So, and real quick, so I can't see the chat. I don't know if you guys are asking questions. I do apologize, but when I open it up to questions, because when I'm presenting, it just has the slides on my screen. So I forgot to mention that earlier. So that's what I would be including. Those are the 12 parts that I would include on a statement. And again, if you want copies of these slides, just let the organizers know they can forward them on to you. So the last thing, I'm just going to take a couple minutes. So the Safety and Agricultural Tourism Act, I think when I looked it up, it was 2017 when it passed. Despite the fact that 6 years ago, this is still a new law. There is not a lot of case law. There are not a lot of things out there. So it is still a new law. There's still some gray area when it comes to this. But for the most part is if the owner, operator, they're not going to be held liable for injury or death as long as the provisions. So GOL stands for General Operating Law. So you can look this up. The law itself is only about a page long, but General Operations Law for New York State, Section 18303(1), and it's sections A to E. So, and I'm just going to quickly go through what those are. So number one, you need to have directional signage. So you need to be putting a post up there for the signs of where are they allowed to go? Like, is there a path they need to follow? What areas are open to the public? What buildings are open to the public? As well as you should have, if anything is off limits, employees only or something like that with the sign. But especially if they're going to be going anywhere on the farm or on the business property, that you have directional signage directing where they are allowed to go and where they're not allowed to go. Employee training, you as the owner are required to provide employee training adequate to whoever is going to be involved in these activities. And quite honestly, this is going to vary based on, what activities are you presenting. So when you look at the law, and this is why, even if you find there's kind of a summary sheet that explains a lot of this, but even there, it tells you, talk to your attorney, talk to your insurance, because it's going to vary greatly for, someone who's doing farming activities and allowing people to come in and maybe try things for themselves versus someone who's just doing a you pick, fruits or vegetables yourself type farm. So, but the employee training, you are required as the owner to provide employees with adequate training, depending on the activities they're going to be involved in. Warning signs. So you're supposed to post warning signs that show what the risks are of participating. And they indicate, so the way the law is written, those warning signs have to be every place where there's a point of sale. So, if you are just ringing everything up in one place, it would be that point of sale. But if you are selling tickets somewhere else, those warning signs are supposed to be, wherever the tickets are, as well as any kind of point of sale. So if you have an entranceway for tickets and you have a gift shop, they're going to need to be in both places. So, but you need to post the warning signs of the inherent risks. Again, they don't specify exactly what the risks are because the risks are going to be different depending on the activities that you are allowing people to do on the property. You are supposed to provide written information to the visitors. So to me, this is that contract that we just kind of went over, as long as you have the information in there. But you would want something to make sure that you bring their attention that, look, we have warning signs. You need to observe and follow all warning signs. So, and you can give more written information of more of the risk than just the signs as well. But at minimum, you have to provide them with some type of written information, directing their attention to the signs and asking them to observe all the signs. Visitor responsibility signs. You also need to have visitor responsibility signs. These are also supposed to be put up at all the points of sale. But what are the visitors' responsibility? And basically, at least what is set out in the law, that they exercise reasonable care, that they comply with any signs, the directional signs that you put up, that they stay in the designated areas, that are not going to leave to areas you're not allowed to, that they will follow the rules, and that they will not damage the signs. So again, this can all be part of the written information that you provide to them, but you have to post part of this as a notice. And, New York State does provide you with samples of what those look like other than the specific activities and the specific risk that they deem. But and then you also have to post a right to refund. So if anyone is unwilling to accept the risk or the responsibilities, if they're not willing to sign the contract and they had already bought a ticket, then you have to refund, but you have to post that as well. So that you have to put up in post, which I would put up at any sales transaction places. And then finally, your duties under the law is you have to take reasonable care to prevent foreseeable risks. So foreseeable risks, they don't define exactly what they are going to be because it'll depend on the activities. But if it's something that you can reasonably imagine happens, that's going to be the foreseeable risk. So those are going to be your duties under the law as well. So with that, I'm going to open to questions, and I'm actually going to take the slides.
Okay. So thanks for having me here today. I hope everybody can hear me okay. This is my first ever Zoom presentation. So we'll see how I do, and you can score me at the end. So I was asked to discuss the importance of agritourism insurance. Obviously, as an insurance agent, I believe insurance is extremely important to protect your assets. So the question is, what is agritainment? This is the session agenda. What do I need to consider when I choose an insurance agent or a carrier? What do I need to insure? The coverage basics. How often do I need to review my policy? How do I handle accidents? What do I do if legal action is taken? And then, of course, questions. So just understanding what is agritainment. And it's any farm-based entertainment, including activities such as hay rides, pony rides, wine tasting, cornfield maze contests, harvest festivals. Pony rides, are a big one, I'll tell you. Here are some examples: little train rides, those big slides, you pick. I know people love to have like hay towers and anything kids can climb on or potentially fall from. Agents and carriers. So choosing an insurance agent and an insurance company, there are different types of companies. So you can choose a brokerage who's going to have access to many different carriers, or you can choose a company that has just one policy to work with. So I work for Farm Family Insurance. It's an American national company, and I am captive with Farm Family. So if you obtain a quote from me, I can't go out into the market and compare prices. I can only sell you my policy. So the benefit of that is I know my policy well. I know all about the insurance and our coverage, but I'm not going to know about other people's policies very well. So I can't advise you on another policy type. I can really only talk to you about Farm Family. So I would always say to you, you have to ask your agent or an agent that represents that company to get a clear answer. So if you look at this, I said the AM Best rating. I don't know if many of you know anything about AM Best, but it's one of the organizations that rates insurance companies on their ability to pay. So if there's a major issue, say there's a huge windstorm and it takes out everybody's barns, can that company pay to replace all those barns? How well rated is that company? Then I go on to the knowledge of your risk. So when you're looking for an agent, you want to find an agent that actually understands what you do. What is your risk? So I'm not somebody who wants to insure funeral homes. I don't know anything about them. It's something my company is really good at, but I stick to agricultural risks because that's what I'm good at. That's what I know about. Agent access. You want an agent you can call, you can get in contact with. You don't just want access to their secretaries. You want access to your agent. Is your agent credible? What do people say about that person on the street? Do they say they can get a hold of them, they're good, they've been good at crisis situations? So, ask for people to refer. So who are your friends using? Who are other people in that industry using for an insurance agent, and are they happy? I always say trust your instincts. If you meet somebody and you like them and you trust them with your risk, and you feel right about them, there's something to that, because when everything falls apart, you need that person to be there for you. And then pricing is important. You have to be able to afford the policy, but you also have to understand sometimes that you get what you pay for. So you may have a policy that's not very expensive, but hey, what's that company's AM Best rating? Do they have the ability to pay? Sorry, I'm kind of trying to move you guys around. Another issue or question is the type of policy you have. So you can get an occurrence policy, which is what we sell. And that's an occurrence policy. It protects a business from any covered incident that happens during the policy period, regardless of when a claim is reported. So this type of policy will cover a business even if the claim is filed after the policy is canceled, as long as the incident occurred within the time frame enforced by the initial policy. And we have an example here that you can read, but you just want to make sure that you're going to be covered. So just because you cancel a policy doesn't mean that you shouldn't have coverage for what happened during the time you were insured. The other type of policy is a claims made policy. And a claims made policy provides coverage for a claim that occur and are reported within a specific period of time set forth by that policy. So if the policy is canceled or a premium isn't paid, any claim that comes through, they won't necessarily cover, even if the incident occurred during the period when the policy was active. They also have that claims made policy. You can buy tail coverage that will extend the reporting period, but you just really need to be aware of what you were purchasing. Coverage basics. So I can talk to you a little bit about our policy, specifically with farm family insurance. And our special farm package is the policy that we insure any agricultural risks or anything related to agritourism. So it's broken down by division. In division 1 through 5, we can insure your house and your house contents. You could have rental houses on this policy. You could have your lake house on this policy. We insure outbuildings and the contents of those outbuildings, farm personal property. So you have, pumpkin cannons or apple cannons and other items that you need insured. They can be covered under that farm personal property. Division 4 is related to, diamond rings, musical instruments, guns, things that are antiques, things along those lines. And then Division 5 is what we really care about here, and that's your liability. So farm family insurance is really interested in farm activities that exceed $2,000 in income or have more than 4 large animals. And that's what you'd have to qualify for our special farm package. We consider most farm types. We don't like anything to do with marijuana. Agri-tainment exposures are addressed in our Division 5 liability. And I can't see any questions either. So if any are coming through, I don't know. Division 5 liability coverage has your farm liability, your personal liability, and your business liability. So it doesn't even have to all be farm liability. So maybe you do have demonstrations that aren't related to the farm. Those could also be covered on this policy. This is just a quick page to kind of show you Division 5 liability coverage so you can see what it would look like on a policy and the limits. So in most states, your occurrence limit, I always insure everybody at 1 million, 2 million. So per occurrence in aggregate. So we'll pay out up to $1 million per occurrence, 2 million aggregate. So we won't pay out over $2 million on this underlying policy in a year. You can choose 1 million, 3 million as well. And the limits, if you can see below, B through F are set limits with the exception of the excess fire legal liability coverage. So if you're using a neighbor's building, you're renting it from them, you can increase the coverage for the building. So the fire legal liability, maybe it's really 300,000 is what it should be. And there's an additional fee to do so. This isn't really a fun slide, so we're going to go through. This is something that I get to look at as an insurance agent and the underwriters look at. So you can take a second just to quickly look, apple, corn, potato, pumpkin, cannons, or slings. There's a description for it. And that says the use of any device on the insured premises that is designed to throw objects as a form of entertainment. Okay, so we're okay with them, but you have to look at the ineligible risks. Well, what do you have to do for us to be okay with you having this risks? We don't want them to be near a roadway or a residence because we don't want to pay for windows or cars that get hit by the apple. We don't want you having multiple operating at one time. We don't like catapults. And we want somebody to supervise. We don't want people left with these cannons and nobody supervising. So you can see we also like the corn mazes and the farm tours. And you can see with farm tours, we're saying there aren't any ineligible risks for farm tours. But every time you look to add an activity to your property, it's always wise to contact your insurance agent and say, hey, can I get insurance for this risk? And if I can, what are the rules associated with adding this to my policy, and how much is it going to cost? Because you have to make sure when you have a business that it's going to be worthwhile and you can make enough money off of adding that exposure. This is another example of what the policy looks like. You can see up at the top the coverage, and this policy has $1 million per occurrence, $2 million aggregate. And these are just some included coverages. But on this farm policy, you can see we have children's playgrounds, hay mazes. They have a petting zoo, haunted house, train rides, inflatables, picnic areas, and social business events. So the social business events would be something like you're going to, allow everybody to come in for face painting for a day, or you're going to have a princess parties that day. That would be a social business event. Understanding underwriting a little bit more, underwriters are going to spend a lot of time reviewing your risk. So what are you putting out on social media? What's on your website? What are you doing? Because anything that is not listed on that policy with my policy is not insured. It's not covered. So if you have a pony ride day and you don't have pony rides on your policy and somebody's injured, you have no coverage for that day or that injury. And you don't want an open exposure. So we take time, we make sure that we're covering you for everything you're doing. We also may send out an underwriting team to look at your facility and make sure that we have you covered properly. So it's a loss control inspection. One of the questions that I was asked was, hey, how often should you review your insurance policy? And a minimum of once a year. Even if nothing has changed or you can't remember that something's changed, it's always smart to have an insurance review. And also if you change any aspect of your business, so did you build a structure and forget to tell your agent? If you don't want it insured, it's not a big deal. But if you put a lot of money into a building, you may want insurance on it. Did you add any exposures? Did you remove any exposures? Maybe you no longer have pony rides. Well, you don't want to pay for anything that you're not currently offering. So I just said, when in doubt, call your agent. It's better to be on top of your business. And then I just kind of liked this. This was so funny because everybody says, well, what can go wrong? And I'm really not very fun because I think of all the things that really can go wrong. It's never what you think is going to happen. But, with petting zoos, little kids get bit sometimes and you get sued. Or, somebody wants you to pay out because they had to go to the emergency room. Their kid had to have stitches and it's all your fault. So just being sure that everything that every exposure you have is covered on your policy. So I was also asked about incidents and claims. What do you do? So something happens, something terrible happens on the farm, and how do you take care of it? I always suggest having an incidents report form, and you might actually want to ask your lawyer what they prefer. But for us as an insurance agent, what we like to have is a report that states the date, time, what happened, and who was present during the incident. What actions were taken? So, we want a narrative. What happened? What did you do? So was medical attention accepted or declined? You always want to offer to have that person taken care of. And you always want them to sign this form. So you want a place where the manager or the owner of the property, they're signing this form along with the injured party or the injured party's parents if they're under 18. So say, you did all of this, you have your incident report form, and you receive a letter in the mail and you're being sued. So what do? You do not go on Facebook. You do not talk about the incident with anybody besides your insurance company. So once you've been notified you're being sued, cease all communication with anyone other than your insurance company. Don't discuss it. Forward your paperwork to your insurance agent right away. And like I said, just stop talking. I feel like people get into a lot of trouble because they want to defend themselves, but they really just need to stop. And at this point, it's up to the insurance company what happens and how this claim gets settled. You don't really have a say in it. The insurance company is going to do whatever they can to settle that claim and pay out the least amount of money. They're not going to spend time in court if they can settle, which might sound terrible, but it's true. And that's what keeps your insurance rates lower. And then I found a little bit of information that claims-based versus occurrence policies. I just found that information online. It was a little bit easier than me trying to explain it. And then Rebecca Clark, who's our director of underwriting, was also very helpful in providing me with information.